All right, guys, thanks for joining me today. We're going to talk about five differences between Chapter 7 and Chapter 13 bankruptcy. My name is Matthew Wegner. Let's talk about why you might want to file for bankruptcy. Bankruptcy is a legal process that allows individuals and businesses to get relief from their credit card debts or other lenders. Several types of bankruptcy. Most individuals file Chapter 7 or Chapter 13 bankruptcy. Other types of bankruptcies include Chapter 11, which is usually used for businesses, but that can be used for what we call a high net worth individual. Think somebody with millions of dollars, extremely successful, doctors, dentists, athletes, things like that. Those folks would probably use a Chapter 11. There's Chapter 12, which covers family farmers and fishermen, and Chapter 9 for municipalities. Detroit filed its own bankruptcy years ago. That was done as a Chapter 9. There's been a few others, but it's not real common. So today, what we're going to talk about are five common differences between Chapter 7 and Chapter 13 bankruptcy. Now, like I said, my name is Matthew Wegner. I am the attorney here. I'm the founder of attorneywegner.com, Wegner Law Firm, PLLC. I practice bankruptcy pretty much regularly since 2006. I've helped people eliminate, millions of dollars of debt. I've saved their homes, saved cars, helped people reorganize debts related, to their personal life. I've also helped small businesses file Chapter 7, just get a fresh start. My office is located in Fort Worth, Texas, although we can help people all over the Metroplex. We don't typically go down to Houston or out to El Paso or anything like that. But if you are in the Dallas-Fort Worth area and you would like to talk about bankruptcy, give me a call. You can see my numbers there, 817-494-3344, or you can go on my website, attorneywegner.com. In the top corner there, you can schedule a free consultation. Now, the biggest difference, I think, between a Chapter 7 and a Chapter 13 is that a Chapter 7 bankruptcy is a liquidation versus a Chapter 13 bankruptcy, which is a reorganization. But what does that really mean? So, a Chapter 7, a liquidation bankruptcy, what you need to know is that most of your property is going to be protected from liquidation. We have exemptions here in our state. So, the state of Texas, we can either use the state exemptions or we can use federal exemptions. And this gives us a lot of flexibility to protect the majority of your assets. Now, if you're living here in Texas and you have a lot of equity in your home, then your case will have to be run under the Texas state exemptions. That protects your home, that protects a couple of vehicles, one vehicle per licensed driver. Most of your personal assets, up to I think it's about $60,000 of personal assets that we can protect. So by and large, everything would be protected in a Chapter 7 under the Texas exemptions, except money in your checking or savings account. Money in your checking or savings account is not protected under Texas law. In order to protect that, we have to use the federal exemptions. However, the federal exemptions really are not effective if you have more than about $15,000 to $20,000 of equity in your home. Now, if you are a renter or you're living at home with friends or family and you don't have any property, you don't have a homestead, then most of the time we're going to want to use those federal exemptions because that gives us a lot more flexibility to protect your assets. Now, whether you do the Texas exemptions or you decide to go with the federal exemptions, either way, your IRAs, your 401ks, those types of tax exempt accounts are going to be protected. Your tax exempt retirement account, no matter what, will be protected under either Texas exemption law or federal bankruptcy law. As I mentioned before, if you have a homestead, you have a lot of equity in it, then Texas exemptions would be used to protect that. Um, so that gives you a pretty good rundown of those exemptions. Now, on the other hand, we got Chapter 13, and that's a reorganization. So in a Chapter 13, you don't have to liquidate any of your assets. It doesn't matter if you have 10 cars and 3 houses or $1 million in your bank account. You won't have to turn over any property. However, Those items, whether they're exempt or non-exempt, will factor into how much repayment you're going to have to make. So if you have $100,000 of non-exempt assets and $50,000 of debt, the court's basically looking at that and saying, look, you've got enough assets that you could sell some things and pay this debt off. But since you don't want to do that, we're going to go ahead and reorganize under Chapter 13. But the catch is that you have to pay everybody back. So that's something to be aware of. Again, however, Chapter 13 is really effective if you do have a lot of assets and you want to make sure those assets are protected. There are some timeline differences that you need to be aware of. Chapter 7 bankruptcy is a lot faster. From the day you file it to the day you discharge is usually going to be between 110 to 120 days, just depending on the court. You're going to have one hearing that you have to attend. It's called a 341 hearing. Basically, all you have to do is log in. It's done by Zoom at this point in time here in the Northern District of Texas. So you log into your Zoom hearing. Attorney from my office will be there, either myself or Caden Pratt at this time. And we will ask you a few questions. Hey, do you remember coming to my office and you discussed your finances and you decided to do a Chapter 7 bankruptcy? You provided us with all your personal financial records. You're not aware of any changes you need to make, et cetera, et cetera, et cetera. We'll ask you to briefly explain why you had to file bankruptcy, things like that in the Chapter 7. Um, so it runs pretty quick in the Chapter 7. It's really made to kind of grip it and rip it, as we say. You know, you're going to give up some things potentially, but you are going to get that fresh start so that you can move on with your life. Now, Chapter 13 bankruptcy is a little different. You're looking at a 5-year repayment plan. There are some situations that we are allowed to do a 3-year repayment plan, but most of the time we're looking at 5 years, 60 months as your repayment plan. You're still going to have that same 341 hearing within the first 30 to 45 days. So that doesn't really change. Again, that hearing is 5 minutes long. It's pretty tame. And again, you are represented in that hearing. There are other things in a Chapter 13 that take place about 25, 30 days after your 341 hearing is something called confirmation. Now, generally, you don't have to attend that confirmation hearing. My office will handle it. But there are situations that come up where the court is going to want some testimony from you, especially if we haven't been able to resolve an objection, maybe from a car lender or a mortgage lender or some other person, or sometimes the trustee's office will object, and it's harder to get a resolution done and get the case going. In a Chapter 13, your first bankruptcy payment is going to start about 30 days. It will be due 30 days after you file bankruptcy, so you need to make sure you get that in. Trustees around here have a real short leash on you, so it's really important that you get the first payment in on time and that you're current by the time we get to confirmation. As I mentioned, 3 or 4 months down the road, we need you to be current, otherwise you cannot get your case confirmed. Chapter 7 and Chapter 13 have a lot of cost differences. Again, Chapter 13 is a much longer process and it can be a lot more involved. Chapter 7s are usually pretty straightforward. Now, with the Chapter 7, a lot of the work is done on the front end. We're going to go through all your bank statements and pay stubs and tax returns and a bunch of paperwork that you submit to us. And we're going to use that to prepare all the schedules and statements that we have in your case. Um, So fee wise, you're going to be looking at a range between 1,500 on the low end. You know, I've seen Chapter 7s, up to $5,000 on the higher end. Again, that $5,000 Chapter 7 bankruptcy is probably going to be an individual with a business with multiple assets, a few more moving parts. While on the lower end, you can imagine an individual that's just on, Social Security disability, has $25,000 of credit card debt, and just needs a fresh start to deal with that. So those are kind of two extremes that we work off of. Now, there are some law firms that will bifurcate your Chapter 7 fees. And what that means is that you're going to pay a portion of the fees before you file and you'll pay a portion of the fees after you file. Now, that is an issue within our industry as to whether or not that's ethical. Obviously, you're essentially going to come out of that Chapter 7 bankruptcy. If it's a bifurcated fee situation, you're going to come out of that Chapter 7 bankruptcy with some fees that are due. So you'll come out still having debt to your bankruptcy attorney. There's also a question in the Chapter 7s. Most of the work, if you do it right, is done up front. And so what a lot of these folks that are bifurcating the fees, they're taking a small amount up front. They're filing what we call a bare bones, meaning that there's no real information in that bankruptcy schedule. And so they file this bare bones, and then they bill you post filing, they'll bill you for generating all the schedules and documents that are needed. The problem with that is if you haven't reviewed all the bank statements and prepared all the schedules and the pay stubs and all the documents that we need, tax returns, things like that, then there's a real question as to whether or not an individual is going to qualify for that Chapter 7 bankruptcy. And there's a question whether or not the attorney that's helping you has done the proper due diligence to ensure that you're not going to have any problems with your case. So you need to be real careful with it. As a consumer, just make sure you understand the rights and duties that you have. What are your obligations to the attorney, and what is the attorney going to do for you? Again, especially if they're bifurcating that payment situation, make sure you understand who gets paid and how much. Now, Chapter 13 has a fee that is set by the court. Right now, that fee is $4,250. So you can come to the Attorney Wegner law firm. You can go to several other law firms in our area, and that total $4,250 will be the same. There are a la carte services. Again, those fees are set by the bankruptcy court. You can imagine over 5 years, a lot of things can happen. You might want to sell a house or take out a new loan. You might fall behind on your bankruptcy because of some kind of illness or job loss. All of those issues that can come up can be addressed within the Chapter 13 bankruptcy. However, you must make sure that you're letting us know, and there are going to be some additional costs. At my office, we lay those costs out when you sign up. We have a sheet that goes home with you that outlines all of the a la carte services and the fees that are set for those items. So again, the name of the game is just make sure that you understand what you're getting for your money. Another big difference. Chapter 7 has an income qualification. In 2005, they passed the Bankruptcy Reform and Abuse Act, which basically was set up so that fewer people would qualify for Chapter 7 bankruptcy. And that's been effective. It used to be in the past that you just had to demonstrate that you couldn't currently repay your creditors, and maybe there's been some kind of change of circumstances. But the Congress, in their wisdom, thought that people were playing the system or gaming the system in some way. And so they created some means testing requirements. So since 2005, if you file a Chapter 7 bankruptcy, you have to comply with the means test. That means that we're going to get 6 months of your pay stubs for your household. So everybody that's responsible for bills, so typically that's the two spouses or an individual. We're really not looking towards the kids or something like that. If one of your kids is working, unless they're contributing that money into the household, that's not something that we're really worried about. Um, but those income numbers are set by by the Department of Justice, and they change every quarter or so. Right now, median income for a household of four in Tarrant County is $110,719. Now that is a gross amount, so that's before your taxes and insurance or anything is deducted. It's not what you take home; it's what you made before those deductions are taken. Now that number, if you have three people, it's lower. If you have five people, it goes up. Um, if you're pretty close to that, if you're at 115 or so, you're probably still going to qualify for the Chapter 7 bankruptcy, depending on what kind of deductions we can use for the means test. Um, But that is really a key difference because you see here, Chapter 13 bankruptcy does not have those kind of income qualifications. It really does not matter what you earn in a Chapter 13 bankruptcy. Um, that will impact how much your payment is, but you're going to be able to qualify for the bankruptcy. Um, what the court's looking at in these Chapter 13s is, again, they're looking at your gross household income and your household size. They were going to take out any deductions, taxes, insurance. 401ks are currently deductible. That's a whole separate issue that's going in some other districts. But all those things we come together and we calculate out a creditor pool and do some projections, and it's a little complicated, but basically we'll figure out how much you have to repay. What's the maximum amount that you could be required to repay, and then we'll look at how much actual credit card debt or medical bills or whatever it is that we need to address. In a Chapter 13, there are some income restrictions. Right now, it's $526,000 of unsecured debt or 1.39 million in real estate debt. And so if you're up over those numbers, then you're either going to have to do a Chapter 7 and liquidate, or you have to do a Chapter 11, probably a Chapter 11 subchapter 5, which would again help reorganize some of that debt if you don't want to liquidate. One of the final difference between the Chapter 7 and Chapter 13 is how they deal with your secured creditors. A Chapter 7, because there is no repayment plan, is limited to surrender, reaffirm, or redeem on a secured item. And we're excluding your mortgage. I'm really talking about vehicles or maybe equipment if you had a small business. Surrender, straightforward. Hey, I'm not going to be able to pay for it. You let the creditor come pick up the vehicle. You will no longer have any liability on that vehicle. You'll get out from underneath it. Reaffirm means that you're going to keep making those payments. We're going to have you sign a document that legally reinstates your obligation to make those payments. The advantage to doing that is that those payments will be reported back to your credit report. So that helps you rebuild your credit worthiness pretty quickly. But you are on the hook for it. So if you reaffirm a debt like your car loan and then you later default on that car loan, that will go negatively against you on your credit report. You will be liable for any unpaid balance if that vehicle is repossessed. Redeem, we don't see that too often, but that basically means that you pay off the loan for the value of the item. So usually that means a reduction. So let's again take a car. You owe $25,000 on your car. It's worth $15,000. We could file a motion to redeem that vehicle for $15,000. But if we do that, you have to be able to then pay the $15,000. So if you're in bankruptcy, you don't usually have that available to you. So one of the workarounds with that are there are lenders that specialize in lending money to people who are in bankruptcy for the purpose of redeeming a loan on a vehicle. So if that's something that's interesting to you, make sure you talk to me about it when we're in the office, and I'll walk you through that process. Now, in a Chapter 13 bankruptcy, there is a payment plan, so we can either just what we call pay the claim in the bankruptcy. So we'll say that you owe $25,000 on that car. You think the car is worth about $25,000. So we would just put that loan and have it paid over the 5 years of your bankruptcy, instead of you having to handle it as a separate bill. That's pretty effective, especially if you're just a month or two behind on the vehicle and you want to keep it, and you're working now, but you just can't catch the vehicle back up. That's usually what we're looking for. Of course, you can still surrender a vehicle in a Chapter 13 bankruptcy. It's a little different. The vehicle will be sold at auction, and then that deficiency balance will come back around, back into your unsecured creditors, and would be paid with whatever amount of unsecured creditors that you're paying. Now, with those unsecured creditors, you may be paying 1 cent on the dollar or 100 cents on the dollar. So you need to make sure you understand how much of that car loan you're still going to have to repay if you decide to surrender it. One of the great things that a Chapter 13 bankruptcy can do that cannot be done in a Chapter 7 bankruptcy is a cram down. Now, on a vehicle in particular, if you've had that car more than 910 days, before we filed the bankruptcy, we're going to be able to cram it down so that you just pay the value. And then the upside down portion, what we call an unsecured portion, that'll be added to your unsecured creditor pool. So again, in most cases, you're only paying 1 cent, 2 cent, 5 cent to those unsecured creditors in a Chapter 13. So it's really going to reduce the amount that it's costing you to have that vehicle. Equipment is similar. Equipment has to be purchased 1 year before the bankruptcy filing to be eligible for a cram down. But the same thing, you got Bobcat, you got skid steer, something like that. We can really cram those guys down, have them take less than what's owed on the note, and give you a fresh start. So those are 5 common differences that we see between Chapter 7 and Chapter 13. Obviously, we need to give you the disclaimer. This is not legal advice. If you're going to file bankruptcy, you need to talk to an experienced attorney. You and I have never met before, most likely. So I'm happy to talk to you. If you'd like to, you can make an appointment, attorneywegner.com. On the top corner, there is a make your appointment. I think it says free consultation or something up there. So you can get that set. You can also email me, Matthew@attorneywegner.com. I'd be happy to try to email you back as quick as I can. That's really all we got today. I appreciate you taking the time to watch this. Send me any questions, and I'll be happy to try and answer. Have a good day.